Welcome back. Now we take a look at our next conversation, which we said is definitely going to be very interesting. The private jet controversy continues. For some months now, the Minister of Petroleum Resources, Diezani Allison-Madueke, has been answering questions before the House over the alleged expenses of 10 billion naira on private jets. Mrs. Diezani Allison-Madueke on Thursday instituted a fresh legal action against the two chambers of the National Assembly, challenging their powers to probe allegations that she spent 10 billion naira on chartered private jets. She feels she has the right to use it because her office demands the usage of such way of transporting herself from one location to the other. The minister filed this suit on a day the House Committee on Public Accounts invited her and the Group Managing Director of Nigerian National Petroleum Corporation, NNPC, Mr. Andrew Yakubu. And then, of course, they invited FAN to appear before it on June 15 to explain their roles in the alleged 10 billion naira jet scam, as they call it. Now, there are a number of issues that has come out from this, and that's what we want to look at. Is it a case of there's a court proceeding, so the House should not be doing anything? Or is it a case of the House has a right to do what it's constituted to do through the powers within the Constitution to investigate issues of this nature? Or will ministers have the right to tell the House, you cannot investigate me, I am going to court, and I will make sure you're perpetually injuncted. If there is any such word, you will have a restraint for the rest of your term in office to not investigate this matter. This issue will be discussed by having with us Mr. Jiti Ogunye, legal practitioner. Good morning and welcome.
Good morning. Thanks.
And then, of course, we've got Mr. Agua Kariga. Good morning and welcome as well.
Thank you so much for inviting me.
Yes, let me start with Jiti Ogunye. Perpetual injunction, some people have said, is what the Minister for Petroleum Resources crave, to say that the House should not at any point in time investigate or probe this. Do you think this is a good way forward, that ministers should ask for perpetual injunction?
Well, it is hard to say whether what the Minister of Petroleum Resources wants is a perpetual injunction. And even if I do believe that that's what she's looking or going out for, because the matter is now in court, it will not be right to dabble into the details of that matter. What we can, however, do is first to acknowledge that now a matter is in court, and that the National Assembly, and in particular the House of Representatives, have been put on notice that a matter is in court. In legal parlance, you now say that the matter is sub judice, or that there is a lis pendis, that the matter is now in court. And since the matter is in court, the golden rule of behavior or reaction to such legal proceedings is that you exercise patience and allow that process to run its course. Otherwise, the legislature may then be resorting to what we call self-help, resorting to self-help. I don't think that deferring to the judicial process running its course is an exhibition of legislative cowardice or parliamentary pusillanimity, if you ask me. No, rather, it's an act of parliamentary courage to allow lawyers that are retainers of the National Assembly to earn their fees by engaging in that legal battle and if they feel strongly that they're being stonewalled and that the exercise of their legislative function is being hamstrung, they have a duty to challenge that action and urge the court to dismiss it.
So what do you say to a situation where some members of the National Assembly, especially the House of Reps, say that there was a time that they thought that the Ministry of Petroleum Resources and NNPC already had an injunction, but the judge said that there was no such injunction?
No, let me be very clear. It is not open to you as a party to say, because an order has not been made to restrain me, I can go ahead in a way that will be tantamount to overreaching the other side or foisting a fait accompli on the court. Let me be very clear, and I can expatiate on this. Now, I have looked at this, and I can tell you that yes, the attorney of the Ministry of Petroleum Resources, Chief Mike Ezekonis, Senior Advocate of Nigeria, in recent time had reasons in the public domain to take certain positions with which we disagreed, both in our written intervention and in our media intervention generally. And I can cite example quickly. First, the Lawan Farouk, explanation in the media, trying to explain what that videotape was talking about. Second was the position he took on the CBN governor, saying that the president had the power to, untrammeled powers to hire and fire. And thirdly, when unfortunately he was kidnapped and he came out to be saying that kidnappers will be granted amnesty, I said, no, you can't do that. And he said as well that on that occasion, on your program here on Channel Television, talking about the law this week, a colleague of his, and that's why a colleague of his, Tayo Yiti, was Senior Advocate of Nigeria, said, no, you can't say that. But on this one, I agree with him because that is the position of the law. Meaning that once you submit a matter to adjudication, the law says that you must allow the court to determine the matter first before you take any step. And the reason why that is so is that our democracy is undergirded by the principle of separation of powers. You hear judges saying in their decisions that they cannot legislate, that even if a legislation is bad, it's for the House, it's for the National Assembly to correct it. In the same fashion, the House is not expected to take over the functions of the judiciary. And so once you submit the matter to litigation, there are plethora of authorities on this, starting from cases even before the case of Governor of Lagos State and Chief Ogunye reported in 1986, One Nigerian Weekly Law Report, Part 18, page 621. And the position remains that once you submit a matter to court for adjudication, even if no restraining order is granted, once a restraining order is sought,
then you are restrained.
we put on notice that you should not go ahead. That's what the law is saying. And so when I read in the dailies that he had written to the National Assembly saying, you've been put on notice, this matter is going on, and so you have to stay all actions.
But will the judge then, I'm sorry to interject it, then will the judge then be wrong in saying, I have not granted a restraining order or an injunction from you carrying on what you want to do?
No, that's not my interpretation of what he just said. There was a context here. There was a story in the media that the judge had granted
injunction,
a restraining order. And so when the matter then came to court, thereafter, the judge clarified And the judge called both counsel. I have not granted a restraining order.
So that should interpret or should be seen or deemed to mean that if I haven't granted it, then it is not granted, and that implies that you can do whatever you want to.
No, the judge didn't say that.
No, that's my interpretation. That's the interpretation.
That interpretation is not sequitur. It's not a logical flow from that. All the judge said was, I didn't grant a restraining order.
So what should happen? He hasn't granted it.
I didn't grant a restraining order, and there's a news out there that I granted one. And the National Assembly, the House of Rep, you recall, issued a statement, addressed the media, saying that the judge had granted a restraining order. And the judge explained that I didn't grant a restraining order. Now, that does not mean that since the court had not granted the restraining order, the House can then continue to do.
Well, can the judge?
But if the House does that, it will then be open to the parties that have gone to court to then seek the intervention of the court. That as you are conducting your own proceeding here on this subject matter, the House is also conducting its own proceedings on same, threatening therefore to render nugatory whatever you decided. That would be their duty to do. But I'm saying that as far as the law that I know stands, once you submit a matter to court for adjudication, resort to self-help is abandoned. Because that will be tantamount to the rule of force and not the rule of law.
So let me quickly clarify, but then if the National Assembly decides to go forward while the court is still handling the matter, can the person in question ask for a restraining order against the National Assembly?
Quite frankly, I don't think that the National Assembly will go forward. You see, I don't expect the National Assembly